to product liabilities. Is it correct?
Yes.
Yes. Okay. Comparative negligence. And did you answer the questions that why contributory negligence are not available under strict liability, whereas comparative negligence could be available under strict liability? Did you answer that questions? Or did I raise that questions? Did I ask that questions?
Well, unfortunately, I cannot recall whether we resolved that question or not.
Okay, so now I ask that questions again, okay? So my questions is why, you remember the previous slide, they a sentence here is that contributory negligence typically not about to recovery in strict liabilities, which means that the defendant cannot use contributory negligence as an absolute defense to be released from liabilities under strict liability. Okay. And in this slide, we talk about comparative negligence, and we have a conclusions in the last sentence that may apply in strict liabilities and negligence. So my question is, even though they are very much similar to each other, right? They're different, but they have something similar. Why comparative negligence can apply in strict liability, but contributory negligence usually not available under strict liabilities?
I think that under contributory negligence, fault is an element to be proven, but under comparative negligence, we're talking about the damages, the damage of the plaintiff, and under comparative negligence, it is obvious that the manufacturer or the sellers or the contributor is at fault. And so I think that's why comparative negligence may be applied in strict liability.
But even in the comparative negligence, the defendant who want to use the defense of comparative negligence also have to prove that the plaintiff contribute to the fault, right? What is the key differences? What is the key differences? What is the key reason? What is the most important reason? Anyone have an idea? The main idea is that Nga already pointed out. That is, you remember, for contributory negligence, fault is the key issues that release the defendant absolutely from liabilities. Right? Because if the plaintiff also contribute to fault, and then the defendant can be released absolutely from liability. But under strict liability, fault is not a required element. So therefore, contributory negligence cannot be used as a defense for strict liabilities under strict liability theory. Whereas under comparative negligence, the contribution of fault element just only have to reduce the remedies available. It will not absolutely reduce the liabilities. It does not absolutely release the defendant from liability. So therefore, it's available under strict liability because the defendant will be liable anyway. But because the plaintiff also contribute to the fault, so the damages that the defendant have to pay to the plaintiff can be proportionally reduced. It does not absolutely release the liabilities of the defendant. Clear? Understand, everyone?
Yes, I understand.
Okay, good. So we continue the next types of remedy, defenses available under strict liability or product liability generally, what we call statute of limitation. So what statute of limitations mean? Statute of limitations mean a period of time that requires by law, usually statutory law, that people, if he doesn't not actually, if he doesn't, if you do not take legal action within that specific periods of time, and then you lose the right to take a legal action. So that's equal statute of limitation. Okay. All right. So what does it mean in Vietnamese?
Đó là thời hiệu khởi kiện của cô.
Right, this is the thời hiệu. Yes, this is correct. Okay, so the law always requires that the plaintiff must bring action within a certain number of years from the time that he or she were injured by the defective products, and the limitations periods will be set by its stake. Okay, its stake, right? So its stake will have different rules on how long you can take legal actions under strict liabilities or under product liability for defective products. And if the plaintiff did not take a legal action within such periods of time, and then the plaintiff lose its rights, so it means that it is actually a defense to the defendants as well, because the plaintiff did not take a legal action within such a periods of time. Okay, clear? Do you know about Vietnamese law, whether Vietnamese law have the same concept?
Yes, Vietnamese law has the same concept.
Yeah. And how long you know about the statute of limitation for tort case, for tort legal action? How long you know under Vietnamese law?
Three years?
How long?
3 years.
Yeah, 3 years. Normally 3 years. Okay. All right. Under US law, this is longer. It's about 6 years generally, but there are some specific rules in it of the state in the United States that actually shorten that periods of time. But I do not require you to look at it of the state law, because it's really complicated. You know that in the United States, we have 50 states, and each state may have different rules on this. So you only need to understand the general rules only. Okay, you understand about this? The next times, the next types of defenses available to the defendant is statute of repose under strict under product liability. So what statute of repose mean? Statute of repose mean the periods of time after which the defendant will be released from liability as from the year from the date of in which on which the product was first sold. Why? Do you know why this could be also been used as a defense?
I think this one is related to the quality of the product. For example, if the food product is expired, but the customer or the consumer doesn't check and he or she still use that product, the defendant may use the statute of repose to release from liability.
Yeah. So statute, yes, you are right. That statute of repose could be depending on the expiry date, okay, or the term best before in products. But this is actually about, that is usually food products. But how about for other products? Anyone have an idea of about the products which are not food or beverage. For food or beverage, actually we have expiry day, okay? But how about other products like electricity products or some other products? So what statute of repose mean for those products and why the law actually make available this type of defenses to product liabilities? Why this type of defense available to product liabilities? Anyone have any idea? Anyone have idea? Anyone? So why the law impose statute of repose? Why the law makes statute of repose available to the defendant under strict liability or generally under product liabilities? Because after a certain periods of time had passed from the time the products produced, maybe because of the developments of technologies or developments of scientific, therefore, at the time the products were produced, that defect cannot be detected by the law, by science, okay, or by technologies. So after certain periods of time, maybe, and also because certain periods of time make materials or usually materials or techniques or the industries that the manufacturers based on in order to produce the products is no longer safe for human being, for example. Okay, there may be some chemicals or something would put in the products that or the material, usually material for electricity products would is no longer safe for human being. But at the time it was produced, for instance, scientific developments at that time cannot detect the defect. All right, so that's why the laws make statute of repose available. Okay, all right, that allow the defendant to be released from liabilities. Okay? Is it clear, everyone? Okay, and usually statute of repose could be longer than statute of limitation. For electricity, some states actually provide for 10 years. Remember that statute of repose is different from the time in which the producer or manufacturers guarantee for the quality of the products. They are different. Remember so. Okay, everyone? Okay. Anyone have any questions? Please feel free to ask. So from this slide, we actually stop. We finish, okay, the chapters on product liability, strict liability under US law. Okay. Now we move on to look at special type tort under Vietnam Civil Code. Did your class study the subject called, maybe this is a part of a civil law subject in Vietnamese?
Well, actually, some of us did, but is not included in the legal English course. Is because we study another degree. We study law degree.
So in English, in legal English course, you do not have a subject called civil code, a civil law or something? No?
We do, but we only study for the first part of the civil code subject. But
Yeah.
the non-contractual things we do not study under legal English course.
Understand. Yes, understand. Okay, good. So it's good to know that, right? So now we look at the chapter 5 about special type of tort under Vietnam Civil Code. And we will look at types and remedy and elements of some special types of tort and tort under consumer protections legislation. This is just about the very general idea. So you already look at the definition, okay? At the beginning, okay, you can see. Article 584 of the Civil Code. Okay, and we already discussed the differences between US law and Vietnamese law with respect to the definition, right? And under Vietnamese law, the definitions seem to be very specific, but it have some shortcoming by define a tort in a very specific way. But this is actually come from the differences in the legal system. Okay, the legal system when when U.S. legal system based on by mainly or have its origin from common law, whereas Vietnamese legal system have its origins from civil law legal system, which base our law on written law. Okay, all right. So you see, remember the differences. Anyone have any questions about this? Because I just want to emphasize before we move on to look at the detail. Okay, so do you remember that under US law, we have intentional tort, right? Negligence, right? Okay, and strict liability. Okay, and in each of them, intentional tort, we have intentional torts against person, intentional intentional torts against property, interference with goods. Okay, all right. And for negligence, we have several special types or special doctrines, negligence doctrine. Okay. And strict liability, remember, we differentiate between the two concepts, product liabilities and strict liabilities, or in fact, three concepts: strict liabilities, products liabilities, and negligence. Okay. But under Vietnamese law, it seems to be a little bit different. Okay. So could you please open the civil code? Do you have the civil code with you? If you do not have it, you can look at it on the internet. Okay. If you do not have it in paper. Okay. So under Vietnamese law, we clarify different types of tort mainly depending on the objects that the law, the subject matters that the law wants to protect, and also the purpose, okay, of the tort. So we look at article. Look at article 594. Okay. So please look at these three articles in the civil code. So, may I ask you read the articles? May I ask the questions? Existing self-defense at a type of tort under Vietnamese law seem to be similar to what under US law? Yeah, Châu Long, please.
Yes, it seems to me that exceeding self-defense is quite similar to defense of self to intentional tort.
Yeah, correct. So that is similar to what type of tort? Yeah, it's you refer to the defense of cells under intentional tort, right? Against person, right? So it means that in this case, the plaintiff can sue you under what types of tort? So in this case, the defendant or the plaintiff take a legal action under what types of tort? similar to the Vietnamese, the US law? What type of tort? Similar to what type of tort? Khánh Linh, please.
Yes, so in my opinion, existing self-defense may be applied to the task of battery, assault, or even imprisonment.
Right. Yes. Yes. Good. Good. Okay. Yeah. Yeah. Let me see who have just answered the questions.
My name is Khánh Linh.
Ling. Okay, I see you already. Okay. Thank you. Yep. Good. So you can, even though the name of the tort is different, but you can cling with U.S. law. Always with U.S. law, and it's very much similar. Okay. The next types, existing requirements of emergency situation. So that is similar to what types of tort under strict liability, under US law. Nữa. How about the Article 595?
I think that is related to necessity, which is one of the defense to intentional tort.
Yeah, good. Good. Yep. And it will be available for what type of tort? What type of tort? Under US law.
Yes, I think that this one can be applied to trespass.
Yeah, applicable in what type of tort? Sorry,
Trespass.
trespass. Trespass. Trespass generally. Okay. Yeah, it could be trespass. Yeah, mainly trespass. It could be trespass to land, trespass to goods. Yep, good. All right, very good. How about Article 599?
I think Article 599 is related to vicarious liability.
What type liability? Sorry, I didn't hear clearly.
Sorry, give me a second.
Yeah.
Vicarious.
Yeah, correct. Very good. Vicarious liability. Yep. Right. Okay. So vicarious liabilities in the US law mean the situations when liabilities from one person will be shifted to the other person because of their relationship. And vicarious liability is available under US law, applicable to the relationship between parents, okay, and children, employer and employee, okay. Good. The next one, 587. Okay, so this is the liabilities. You may not see it in a specific type taught under US law, but it doesn't mean that this concept is not available under US law. Okay, so choice liability for damage caused by several persons. Okay, choice liability for damage caused by several persons. And in that case, Vietnamese law under Article or by Article 587. I'm sorry for a second. Okay, so choice liability for damage caused by several persons applies in a situation when several persons caused damage, okay, or loss or injury to someone. And in that case, if it's proven that the percentages of contribution of the person who caused injuries or damage to the other person can be determined clearly, okay, or the plaintiff can prove the percentages of contribution, or each of the defendants can prove the percentages of contributions of each of the defendants, and then each of the defendants will be liable for that specific part. But if it's not possible for them to prove how many percentages of them contribute to the fault, and in that situation, the liability will be equally shared among the defendants. Okay, so that's what provided for under Article 587. And you can see the similar concept of vicarious liabilities under Vietnamese Civil Code in Article 597 and 598. Can you let me know, can anyone let me know the differences between the provisions 597 and 598 and minor liabilities under sections 599. So can you differentiate among them? Do you have the civil code with you? Everyone, I hope you have a civil code with you. Just want to show the civil codes in the English on the screen for those who do not have the civil code can look at. This one's not a good one. I just try to find the other one. Oh, 500 and oh, whether I refer to the different one, let me see. This one is Civil Code 2005. Sorry. Where is the Civil Code here? So you can see on the screen 3 articles of the Civil Code, Vietnam Civil Code. Article 597, Article 598, and 599. Anyone can tell us the differences? So can you have any comments? Do you have any comments on Vietnamese law with respect to this in comparison with US law?
Miss, I think the key difference between three articles is that under Article 597, the legal entity has the right to ask the person who caused the damage to pay an amount of money, while the other two articles do not have the legal entity do not have the right to do so.
You I want you to compare, okay, the law of Vietnam and the law of US with respect to vicarious liability. In fact, in the Vietnamese law, the three article 597, 598, and 599 are very much similar to the vicarious liabilities in the US law, right? But do you see any differences?
So let me check again.
Okay.
Yes, Miss. I
Yeah.
think we have a difference here is that the vicarious liability as to parents and children relationship. So for this case, we could have more than one party liable for the children's act. So under Vietnamese law, it could be school, hospital, or other legal entity. But under US law, tort law, it shall be parent.
But under US law, we also have the liabilities of the employer, and the employer can be entity, right?
I'm talking about the parent and the children
So
relationship.
children and parents are similar, right?
I mean that under Vietnamese law, the party that is liable for the child's act could be school, hospital, or other legal entity, not exclusively parent, but under US law, it shall be parent.
Okay, right. So the difference is that, yeah, actually, because under US law, we study the very general concept. So that's why vicarious liabilities under US law actually apply specifically to special relationship, and that relationships, like an example of parent and children, example of employer and employees are actually examples only. So I want to make clear that under US law, school or hospital still have liabilities if that school or hospitals are over control of the person who are under the age of 18 or who are actually have some mental problems. Okay, so remember that under US law, the definitions under vicarious liabilities is that is a situation in which one person liable for the other person acts because of their special relationship. So it is more general. You understand what I mean? Rather than under Vietnamese law. Vietnamese law seems to be very specific, right? You look at the provision and you see it's a very specific. If it is the liabilities of the parent, and this is actually saying that, first of all, if that children or that person who have mental problem under the control of hospital or school, and hospital and school could be liable unless hospitals and school can prove that they didn't break duty of care. Okay, they didn't break their duty. All right, and if they are not liable because they can prove that they did not break the duty of care, and parent could be liable. Under US law, the similar concept, but we do not, but the approach are different. Under Vietnamese law, because we are based on written law, so we have the provisions like this, and you can see something like this in more details. But under US law, they just only develop a principle that vicarious liability cover the situations in which liabilities of one person is shifted to the other person because of their relationship. And the example given, like employer and employees or parent and children, are just examples. You understand what I mean?
Yes, I understand.
Yeah, all right, okay. And that is a different approach. Under Vietnamese law, we have particular articles, and each article seem to deal with a particular situation, right? But under US law, they have a principle, a general concept, and it can apply in different situations depending on the circumstances of the case, and the church can have flexibilities to apply the law. Understand? Clear about the concept? Clear about the differences? Everyone?
Yes, I understand, Miss.
Yes. And now we look at strict liabilities under Vietnamese law. And strict liabilities under Vietnamese law in Article 601. 601. Is it the concept of abnormal dangerous activities provided for in Article 601 of the Civil Code, similar to the concept of strict liabilities under Vietnamese under US law? Anyone? Anyone can answer the questions? Similar or different? And what are the similar, what are the differences? Dạ, hình như không có tiếng của
Miss, can you give us a hint?
Okay, all right. So you think that the strict liabilities under Article 681 similar to the strict liabilities under U.S. law? So the hint is that you return to the slide that talk about strict liabilities under U.S. law. Similar or not? Look at the regulation here. Look at sub-article 3 here. Look at sub-article 3. Okay, anyway, so think about this, and we will discuss next week, okay? Next week we have 2 different classes, right? One on Tuesday and the other one on Thursday, is it correct? On Wednesday. Next week, we will have class on, on Tuesday and Wednesday. So on, so on Wednesday, do you have a class on 8:30? Can we move it on the same day on Tuesday? On Tuesday, do you have a other class on the second shift? If not, we put together on Tuesday and we finish the code. Can you check? Can you check your class schedule?
On both Tuesdays and Tuesday and Wednesday, we have classes start at 8:30.
Okay. So on so you will have the class with me on Tuesday first shift and Wednesday second shift. Is it correct?
No, both days we start on 8:30. We
Both
start at
days?
8:30.
Well, for also for Tuesday?
Yes.
Okay. So you have other class on the first shift or not?
Oh, my bad. Give me a second. On Tuesday, we have class at 6:40.
Yeah, right.
My bad.
Yeah. That's all right. So according to my schedule, on Tuesday you have the first class, and on Wednesday you have a second class. So may I ask whether on Tuesday we can have the second class as well, or you have another class? Do you have a conflict schedule?
Yeah, we have another one.
Okay. Never mind. Okay. On Wednesday also, right? On Wednesday you have other class on as well on the first shift on next Wednesday, right?
For my schedule, we don't have class for the first shift. However, I don't know whether the students who study
Understand about the situation of your class. Never mind, we keep the schedule, okay? We keep it, all right? Okay, everyone, thank you. See you next week.
Thank you very much, Miss. See you
Okay,
next week.
all right. Thank you, everyone. So we will discuss about the concept of